Discrimination and harassment. So the task is implement, monitor, manage, and promote policies and procedures to prevent discrimination and harassment within the organization and the supply chain. So types of discrimination that are recognized by the Equal Employment Opportunity Commission different are the following types: age, disability, involves treating an applicant or appointed with a disability less favorably. Equal pay compensations require that people who perform the same work are substantially equal in skill and responsibility receive the same pay. Genetic information, can't discriminate based on genetic information about an applicant. Harassment is unwelcome conduct towards a protected class that creates a hostile work environment. National origin, pregnancy, race or color, and religion. And then there's retaliation, which is a form of harassment. Prohibits reprimanding applicants or employees for asserting their rights to be free from discrimination. Sex involves treating an applicant or employee less favorably based on their sex, and then there's sexual harassment. Unwelcome physical or verbal sexual conduct that is perceived as a condition of employment or creates a workplace environment that is hostile. Some laws and regulations. These are from the United States. The Equal Pay Act of 1963. People who perform the same work receive equal pay. And there's the Civil Rights Act of 1964. Makes it illegal to discriminate among employees based on race, religion, color, sex, or national origin. And this is the basis for the sexual harassment laws also now. Created the Equal Opportunity Employment Commission, EEOC. Executive Order 11246 of 1965, signed by President Johnson, prohibits discrimination in federal employment based on race, religion, color, national origin, and sex. And then the Age Discrimination Employment Act of 1967 restricts employers from discriminating in the employment and termination of individuals who are over 40 years old. Equal Employment Opportunity Act of 1972 gives the EEOC the authority to sue in federal court when it finds reasonable cause to believe that there has been employment discrimination. Law is based on the 1964 Civil Rights Act. It just enhances that law. Then there's an interesting thing that happened in the 30s and 40s, 1930s and 40s. National Labor Relations Act in 1935. It's also known as the Wagner Act. This grants individuals the right to organize and bargain collectively, or the right to form a union, basically. Labor Management Relations Act of 1947 was the answer to the 1935 law. In 1935, the Democrats were in charge of Congress. In 1947, the Republicans were in charge of Congress by a large majority. It restricts the 1947 law, otherwise known as the Taft-Hartley Act, restricts the activities and power of labor unions and was passed over President Truman's veto, which means you need 2/3 of the House and Senate to override a presidential veto. It amended the 1935 law. So the Taft-Hartley Act was seen as a means of demobilizing the labor movement by imposing limits on labor's ability to strike and prohibiting radicals, read communists, from their leadership. So the way they got a lot of the Democrats to vote for this was the beginning of the Red Scare in the late 40s and 50s. There were communists everywhere that were being subversive to the government. Occupational Safety and Health Act of 1970, otherwise known as OSHA, prohibits work from being performed under conditions that are dangerous or unsanitary. 1983, OSHA issued the Federal Hazard Communication Standard. It requires workers to be informed of all hazardous material. It's also called the Right to Know Act. Focuses on 5 key areas: identification of hazardous materials, product warning labels, otherwise known then as the MSDS, Material Safety Data Sheets, now is known as just SDS or Safety Data Sheets. Emergency response techniques, written hazardous communication standard, employee training. The American with Disabilities Act in 1990, signed by the first President Bush, requires companies with at least 25 employees to make reasonable accommodations for people with disabilities and avoid discriminating against them. And then the Genetic Information Non-Discrimination Act of 2008, signed by the second President Bush, prohibits employment discrimination based on genetic information about a person. Cancer genes, that kind of thing. And PACCAR's non-discrimination policy, most large companies are going to have one. A lot of medium-sized, small companies have them too. This is what PACCARs look like. Other country and international laws. UN International Convention on Civil Rights and Political Rights in 1966. It's modeled after the Civil Rights Act of 1964 in the US. Mexico has the Federal Labor Law of 1970 and the Labor Law Reform Act of 2012. The UK has the Employment Relations Act of 1999, and the EU has the Treaty of Amsterdam of 1997. Canada has the Employment Equity Act of 1986, and even China has the law of the People's Republic of China and the labor law of the People's Republic of China. Employment promotion law, I guess, of the People's Republic of China. Organizational policies and procedures, the direction should be established at the senior management level, and the policies should reflect that the organization will adhere to all federal, state, and local laws related to fair and equal treatment in the workplace. Court rulings pertaining to employment discrimination. Different U.S. regions have court rulings that reflect their region. So these rulings may be stricter than the U.S. federal laws related to employment discrimination. They can't be looser or less strict, though. Diversity training. Each organization should have a program geared toward meeting its specific needs. Multinational corporations have an awareness of other cultures and practices. Companies should have diversity and cultural sensitivity training, which includes the following: focus on goals and behavior to increase its effectiveness, attach diversity training to performance metrics. Now, there's something called unconscious bias. It refers to prejudices we have but are unaware of, and I guarantee you, every one of us has some of these. Some of the more common types of unconscious bias include the following: affinity bias, the tendency to like people that look like us or have similar backgrounds. This is what usually leads to employment discrimination. The halo effect, the tendency to like people because of one great characteristic they have, such as appearance. They're really particularly good looking. Perception bias, tendency to develop stereotypes or assumptions about a particular group. Confirmation bias was a tendency for people to seek information that confirms pre-existing beliefs or assumptions. And the contrast effect is the tendency for people to make comparisons, especially when going through a large amount of information, otherwise known as stereotyping. Suggested remedies to stop unconscious bias from influencing decisions. Focus on skills and eliminate distractions. Let the numbers speak for themselves. Run statistics. Talk about it when you notice unconscious bias. So stick to the facts and you'll be better off. The U.S. Act that covers intentional offenses, including sexual harassment, providing monetary damages, is the Sexual Harassment Equal Pay Act? No. Civil Rights Act? Yeah, could be. Employment Act 72, EEOC Act 72, National Labor Relations Act. No. So between B and C, and sexual harassment is basically drawn on the 64 Act. So I would go with B. And B it is. Smith is a supply manager for RTV Inc. Smith has been assigned to a position involving the management of employees located in overseas countries. Smith is concerned about complying with local worker and human rights laws and wants to learn as much as possible about countries in which the organization has manufacturing plants and large workforces. Which of the following would be the best resource for Smith to use? Employees working at the local plants in question, no, they probably have all kinds of unconscious bias. Plant managers of the local plants, no, for the same reason of A. RTV's Human Resource Department, could be. RTV's Legal Department, could be. I would probably go with the Human Resource Department because he's going for his initial search. And it is C. All right. Summary. As organizations become more global, supply management professionals need to be aware of laws that impact the workforce both domestically and internationally. U.S. Equal Employment Opportunity Commission, the EEOC, differentiates between the many types of discrimination and harassment, some of which include age, disability, equal pay, genetic information, harassment, origin, pregnancy, race, religion, retaliation, sex, and sexual harassment. The United Nations International Labor Organization has expanded to cover non-discrimination as a priority in the Decent Work Country Programs, DWCPs, of 36 countries. Particular attention has been paid to equal remuneration of racial discrimination and better enforcement of legislation in general. References, in case you're wondering. All right, let's go get some questions. Questions. L6. All right, go ahead and start on them. There's only 5 of them. We'll cover our answers in a few minutes. Go get some answers. Number 1 is Bravo. Number 2 is Alpha. Number 3 is Bravo. Number 4 is Charlie. And number 5 is Delta. All right, so that concludes CPSD. If you just practice some of the questions on a regular basis, you should pass with a 90% chance. Thanks.